Good morning. Welcome to the First District Court of Appeals. We have one case to be argued today, C-24-0617, State of Ohio versus Dominique Hill. I see that counsel are present in the courtroom. Are you both ready to proceed?
Yes, Your Honor.
All right. Mr. Thompson, you may come forward.
Good morning again.
Would you like to reserve time for rebuttal?
3 minutes.
All right. You may proceed when you're ready.
May it please the court, counsel. This case is about the limits of a Terry frisk and the erosion of the Fourth Amendment protections when lawful conduct is treated as suspicious. In this case, once the pat-down of Mr. Hill revealed no weapons, the justification for further intrusion ended.
And in this case, the officer had testified that the pat-down was completed at that time.
Yes.
And do you find that fact to be significant?
Yes, I think that there was nothing in plain feel, a weapon or other contraband in general, and therefore, what else are we looking for, essentially?
So in your estimation, was this a fishing expedition then, after the fruitless pat-down?
Yeah, I think that was the nature of the question. It didn't come up, but there was perhaps a question about the voluntariness of that answer, but that was neither here nor there.
What level of justification would the officer have needed to continue the investigation past the fruitless pat-down?
At that point, some kind of probable cause, I think. Running into nothing every step of the way, I don't think reasonable suspicion would suffice anymore.
And did he have that?
No. Like the trial counsel below, I would argue that none of the evidence that he discovered sufficed for probable cause. The trial court even said that they didn't observe any of the mannerisms that the officer suggested while on body cam. It just credited the officer because he said it.
Right. And continuing with the question that Judge Kinsley asked, what justification would be required? I assume that you would agree that there would be a world in which something else would be discovered or known, and that can arise now for a new basis for reasonable suspicion, or can rise it to probable cause.
Absolutely.
Okay. And I guess that's what really this case is about.
Right.
Is if everything terminated there, then what came up afterwards, and how would that be viewed in the totality of the circumstances?
I think that's 95% of it. I think the other 5% is what came out after was legal. So even that didn't get us anywhere.
Well, could it? I mean, I understand your point to be that the possession of the amount of marijuana that Mr. Hill had was lawful at the time, but certainly people could possess lawful objects, but that could enhance an officer's suspicion at times. Would you agree?
Yes.
I mean, I could possess this pen in a lawful manner, but if we knew that a pen had been used to commit a crime, my possession of this pen might pique suspicion.
I think that a lawful object would require some other indicia that there was an illegal activity taking place. I can't say it. Like a straw, for instance, comes up a lot. I think you'd need to see some powder on it or something to make it to raise your level of suspicion that something illegal was going on.
So you're not asking us for a blanket rule that the possession of a lawful amount of marijuana can never be justification for a search, are you?
No. I think there's a lot of figuring out left to do on that in the world where we can carry 2.5 ounces. And I think a lot of that's going to come up in the context of OVI. But here, with no signs of impairment or anything else to go along with it, like, I don't know, maybe 1,000 baggies and, or something to show that signs of being a drug dealer or something.
Counsel, what about an empty liquor bottle? If there was hypothetically, if there's an empty liquor bottle found in a car, no sign of impairment, would that give the officer any ability to investigate further?
Everything is so fact-specific. I could imagine circumstances where it would and wouldn't. Maybe if it really smelled like alcohol in the car as well.
Maybe a better question. What's the difference between the baggie containing a legal amount of marijuana and a liquor bottle containing liquor, which is also legal?
Ultimately, nothing without something else. Both being intoxicants, I think that the main issue would just be other signs of impairment. And it's not a great parallel with liquor because there's not really an unlegal amount that you can have. So I think that would fall under the impairment unless the person was underage or something.
Is there a distinction in this case between the question that the officer asked, what's in your pocket, and then the officer actually going into Mr. Hill's pockets and physically intruding into that space?
Yes, and I think the trial court had a point there, like that would have been obviously wrong. And if he pulled out the baggie and there was cocaine in it, or what appeared to be cocaine, I think that would be a different story.
Well, didn't the officer ultimately go into his pockets?
He did after he saw the marijuana. So yeah, in a sense, because I'm arguing that there was no probable cause or even reasonable suspicion for that, then that would fall under the same. The trial court's finding, I guess, would be wrong in that regard, that he did in fact go in without any sort of suspicion or probable cause.
I'm not following. How would cocaine be different if there was a bag of cocaine that would have been voluntarily taken out of the pocket?
Because it's illegal, was my thinking there.
Okay.
Whereas marijuana in that small amount was legal.
Well, there was some testimony about burnt marijuana in a vehicle, right? And there was some testimony from the officer about the immediate lighting of a cigar. I'm going to say it the Spanish way, cigarrillo. And that often that's indicative of masking a scent, okay? So looking at the totality of circumstances, the officer already having knowledge of that, and now a baggie of marijuana is produced by Mr. Hill. Explain to me why that it doesn't culminate into probable cause.
I think there's a factual issue with the burnt marijuana, because that was what was in the bag. They didn't see it in the car. And I think it was never definitive. There was never a lab test or anything that it was burnt, but I think you could tell. I don't know who keeps burnt marijuana in a bag, but I think you'd be able to tell the difference in color. But anyway, it comes down to some sort of indicia of impairment. If you're masking, it's not 100% successful. There's no bloodshot eyes. There's no...
Well, but this is not a driving under the influence, so does it really require indicia of impairment?
I think to make a small amount of marijuana potentially useful as evidence, yes, it would.
Okay. One thing that I find interesting is that the officer, what initiated the question about what's in your pocket is an observation of a bulge in the pocket, right? And that also would initiated a pat-down. So the pat-down didn't result in anything, right? Completed.
No. Right.
Asks about the bulge. The marijuana is then produced, right? So what do we do about the bulge now when the marijuana has now been produced?
Well, at that point, I'm trying to remember the order of events, because we know it was lottery tickets eventually. And unlike the Hall case I cited in my reply brief, There was nothing about the bulge that was indicative that it would have been more marijuana or a gun or any other contraband.
What was the testimony about the bulge?
That he noticed it. The video ultimately revealed it was lottery tickets. He asked him, "What are you doing with all these lottery tickets?" He asked the question again.
No, you've answered it.
Okay.
What was the testimony about the bulge? And your
Okay.
answer was he noticed it. Was there anything further?
No, there was some dispute about if Mr. Hill checked both pockets or not when he was looking for his license and phone, but other than that, no furtive movements or anything of that nature.
What was, because ultimately, was it marijuana that was ultimately found here?
Sorry,
What was it that was ultimately found?
cocaine. and
Cocaine,
then-
thank you. That's right, cocaine. I don't know why my mouth said marijuana, my brain was thinking cocaine. What was the evidence, testimonial or otherwise, as to where on Mr. Hill's person, other than a pocket, was the cocaine found?
I never figured that out from the record. Presumably it was on his person, but specifically where, I couldn't tell.
Is there even testimony that it was in a pocket?
No, not that I recall.
All we know is that there was a search,
Yeah,
and cocaine resulted in that, from that, and a bunch of lottery tickets.
right. I'll address it because I think the state is about to, the waiver issue. I think that they would be correct that this wasn't specifically raised in the motions, the legality of marijuana, but I think that it became a significant fact issue in this case. And I'm drawing a blank on the name of the case. It starts with a P. That says Piegler, State versus Piegler, that the appellate courts can decide a legal issue if the factual basis is in the record. And I think that's obviously the case here. In closing, the state mentioned the burnt marijuana as a reason for continuing the search. So I think they relied on it. I think the court at least somewhat relied on it. So I think it is at issue here, and it ultimately is not waived. This court can consider it.
Is that even an issue that we need to reach if the state's probable cause presentation was otherwise defective?
No, if the court holds the pat down, once that didn't yield anything, should have been the end of it, then there's no need to go to the legality of the marijuana.
And you're not asking us, as I understand it, to create some kind of bright line rule about how marijuana decriminalization should or should not enable the police to search a person.
No, we certainly could avoid that entirely here. The marijuana is honestly a bit of a red herring. Ultimately, we have a search that continued beyond its possibly even initiating everything with the pat down and getting him out of the car was questionable, but certainly finding nothing with the pat down should have been the end of the encounter. He should have given him his warning and sent him on his way.
Didn't the trial court find as much, that the pat down should have concluded the interaction, but then he voluntarily produced the marijuana in response to a question?
Right. So that's why I bring it up. Wasn't quite sure where the line might fall there with the trial court's findings, but I do think we can avoid the marijuana issue entirely here.
Well, counsel, this question is a little off-center, but my understanding is under Ohio's OVI laws, having a certain amount of the metabolite from using marijuana in your system constitutes driving impaired. Doesn't necessarily relate to intoxication. So doesn't having some amount of marijuana, burnt marijuana, on your person provide probable cause that you may in fact have the level of metabolite in your system that would violate the OVI laws? In other words, you use And by using, you have the metabolite in your system, and having the metabolite in your system beyond the per se level is a crime.
I understand the question. I'm trying to think it through. The only way we're getting to your blood or urine is through an OVI investigation for marijuana metabolites. So I struggle to see how the fact that you had some marijuana that you can have might be a sign that you could have metabolites in your system to be enough probable cause. I think because you have to go through that OVI lens to get to your the testing, I think that you need something else. I don't think having marijuana in a car alone would be indicative or be probable cause that you are under the influence, and frankly would probably be the end of the industry in the state if it was.
And you're out of time.
Okay,
Thank you.
Your Honors,
Morning.
Good
I'm going to work backwards here. I'm going to start with this waiver issue that we raised in our brief, and our position is pretty clear that the issue of whether or not the marijuana created probable cause here, which is what ultimately led to the search of the pockets. And I do believe, to answer your question, that the cocaine was found in the pocket after Officer Huntington went into those pockets. I believe that's on the body-worn camera. So,
And that's what I'm trying to figure out, where is the evidentiary matter that supports where that cocaine was actually found? Because there was nothing testimonial.
Right. I don't think it was testified to so much because this gets to the waiver issue. The scope of the motion was largely confined to the issue of the propriety of the Terry frisk. Defendant really failed to plead anything relative to whether or not this marijuana created probable cause for a search below. They didn't elicit any testimony on the issue. They made no argument relative to that issue.
Did they have the body-worn camera video coming into the motion?
I'm sorry?
Did they have the body-worn camera video prior to the motion? Was
Did the
defense?
defendant? I really don't know. I'm assuming that was provided in discovery. That would have been in the record. We didn't get that. I would think there would have been an objection had that not been provided prior to the motion hearing. But anyhow, the point I would make relative to this is that there was no pleading in the written motion on the issue of probable cause with marijuana. There was no testimony elicited by the defense on the issue.
Well, why would there have been? Because isn't it the state's burden to come forward with facts supporting the search, the warrantless search? Like, why would, help me understand why the defendant would be eliciting facts about the marijuana?
Well, so I think that there's a couple things going on here, and this actually gets back to Judge Zayas' dissent in the Curry decision recently. It's on the defendant to articulate at the very least why they believe that the search was unconstitutional. Just generally alleging that there was an unconstitutional search, that doesn't put it upon the state to say which exception applies. It's on the defendant to indicate what they believe was unconstitutional about the search, and then it's the state's burden of persuasion to say, no, it was constitutional. So there has to be some kind of a particular pleading
Well,
here.
did the state argue at this suppression hearing that it was unclear as to what part of the search it was supposed to justify?
The state articulated its belief that all that they believed that the defense was challenging was the validity of the Terry frisk. That's on pages 13 and 14 of the transcript, and at no point did the defense go out of their way to dispel the state of that notion. So at the very beginning of the hearing, the assistant prosecutor, Mr. Brown, basically said, my understanding, Judge, is that we're limiting the scope of this motion hearing to the validity of the Terry frisk. And defense counsel's behavior during the motion did nothing to dispel that. All of the questioning was on the issue of, whether or not Officer Huntington observed Mr. Hill behaving in a nervous
But then,
fashion.
I appreciate the part of the transcript that you're calling our attention to.
Sure.
But then the state went on and solicited questions about the voluntariness of the production of the marijuana baggie and the fact that that was then what led the officer to go into Mr. Hill's pockets, and then there was cross-examination about that, and the burnt marijuana justification, and then the trial court made findings and an ultimate conclusion about all of that.
I would probably respectfully disagree with the characterization. I know there were a couple of questions relative to sort of how this search culminated in the finding of the baggie of cocaine. Like, okay, I believe this was on redirect. This was pretty late in the hearing, after Officer Huntington had already been cross-examined about all the stuff relating to the Terry frisk. Mr. Brown asked Officer Huntington, so what happened next? Oh, well, I asked him what was in his pockets. The marijuana came out, and that's when I did the search. That was, from my recollection, pretty much the extent of it. I know there was an argument, well, Judge, the Terry frisk was valid, yada, 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 and oh, by the way, he found marijuana, then that was probable cause. And the trial court agreed with that. The point I would make here is that defense counsel below had about half a dozen opportunities during the written motion, opening arguments, cross-examination, recross, and closing arguments to make some kind of an argument relative to that. And where this puts the state at a disadvantage potentially is that they're now making this argument relative to marijuana and probable cause on appeal. And we didn't really have an opportunity to develop a factual record on that below.
But you did, right? I mean, wasn't it the state that was asking about the burnt marijuana and that was asking about the production of the baggie and that made the argument that it was voluntary and that made the argument that this was probable cause?
Well, everyone in the room, I think, took it for granted because right now, for what it's worth, even though marijuana is legal, State versus Moore and the cases like that are good law. There's
Well,
no...
State versus Moore is a plain smell case.
Sure.
And here we have something slightly different in that
Right.
we have the visible, very
Sure.
small amount in the
Sure.
baggie.
And
So
what I would get into here, though...
what
is-
would the state have done differently? I appreciate what you're
Sure.
saying. What would the state have done differently?
Well, I think the first thing would be a line of questioning relative, and this gets to what Judge Moore was talking about with the significant fact that this marijuana was burnt. You know, the state would have asked Officer Huntington, what exactly did you think he was up to? I mean, we get into what crime or what issue, what illegal activity Officer Huntington believed that Mr. Hill was up to. And I think smoking marijuana in the vehicle under Revised Code 378036 or an OVI with the per se metabolite violation would have probably been a pretty good starting point. The fact that this marijuana was burnt is a pretty significant fact, especially when you take into account all of the other factors that Officer Huntington observed, the nervous behavior, the fact that there was this large bulge, the fact that he had lit up the cigarillo to potentially mask an odor. There's an inference to be made there that Mr. Hill had recently smoked in or outside of the vehicle this marijuana. So I think in that light, even if you accept that the issue was not waived below, there was sufficient evidence, probable cause, to conduct further inquiry into what Mr. Hill was up to.
Well, we do have the video,
Sure.
right? So we can see what happened in the interaction. And there was testimony to the effect that Mr. Hill was calm, cooperative. I mean, we don't have indicia
I think there was testimony to the effect that he was superficially calm and cooperative, that, you know, he was kind of white-knuckling his way through it, but his hands were shaking, he was breathing heavy. You know, the judge said that she couldn't see it on the video, but acknowledged that it just perhaps was not, you know, visible from the vehicle. She credited that testimony, and I don't think there's enough to dispel that. You know, the video doesn't always tell the whole tale. There are little subtle human cues that you pick up on that may not be apparent from looking at the video.
Sure, but do we have any testimony from the officer or anything apparent on the video that would look like the typical cues of an OVI case, like slurred speech, glassy eyes, bloodshot eyes? Do we see any of that kind of testimony showing up in this case?
You know, I don't recall exactly how visible Mr. Hill's eyes were during that. Now, as to slurred speech and some of that stuff, watery eyes, things like that, I think that's probably more indicative of alcohol impairment, and there was no evidence of alcohol impairment, obviously, here. I couldn't tell you, I'm not an expert in OVI, I couldn't tell you what the somatic indicia of marijuana versus, you know, alcohol intoxication are, but clearly the officer thought something was going on with Mr. Hill based on his behavior. So that's the best answer I've got for you on that issue. So,
Was the traffic violation any indicia to impairment under, by marijuana?
Failure to signal could potentially be, indicative of an inattentive driver. I think the other thing was tinted windows, which that would be pretty tenuous to suggest that that was indicative of impairment. It's just more indicative of the fact that he's got an equipment violation going on there.
Exactly.
But
And was he cited for the window tint?
I believe the
ultimately?
intention was to issue a written warning, and that was still ongoing relative to when the search took place. And when the search took place, there was still Officer Mike, I believe his name was, from Courtroom PD, was writing issuing the written citation or writing it up for the tinted windows and the turn signal while Officer Huntington was having this exchange with Mr. Hill. Now, there is one point I would like to make, and it gets back to the Peegler case that Mr. Thompson cited. Now, to the extent that the court is not buying that this issue was waived, I would just say that to the extent that there was a sufficient record, factual record below on this issue of whether or not marijuana creates probable cause to go into Mr. Hill's pocket, there's also potentially a factual record sufficient for this court to find that the cocaine was subject to inevitable discovery because Officer Huntington
Well,
testified.
let me ask you a question in that vein then. Where on Mr. Hill's person was the cocaine located?
I believe it was in his pocket, Your Honor, based on my watching of the
Okay,
body
which
worn-
pocket?
That I don't know.
Okay, so isn't it the state's burden to establish that?
To establish what? Which pocket it came out of?
Sure, to establish the facts of the case.
I don't know what the state's burden relative to that specific of a fact is. I mean, the fact was clearly established, I think, from the record that after the search was conducted of Mr. Hill's person, the cocaine.
What's the evidence that it was discovered in a pocket?
Well, because after Officer Huntington puts Mr. Hill in handcuffs, he starts going through Mr. Hill's pockets. He pulls out, I believe, the wallet, the lottery tickets, all of this random stuff that Mr. Hill has in his pockets. And one of the things that comes out during this is the cocaine. That is my recollection of the body-worn camera. But I would just say that, here Officer Huntington did testify that his intention, based on how this whole exchange was going, the next step was probably to bring out the K-9. And I believe he also testified to the effect that his understanding of the law, which I think is still correct for what it's worth. I know Moore is not the right case, but similar cases that marijuana creates probable cause notwithstanding its legality. So unless the court has any additional questions, I'm going to submit on what I argued here. Thank you.
Thank you.
I think I'll address the inevitable discovery argument first. I don't know that that came up in the state's brief, but I think that it was even the officer who testified himself that said he could go ask more questions of Mr. Hill if he didn't extend the traffic stop. I think he was the one that said that. So I don't know that a canine sniff would be inevitable here.
Was inevitable discovery in the brief?
I don't believe it was.
Okay.
So that's my answer to that. I'll circle back to the very beginning.
Perhaps your answer should be that it was waived.
It is.
Okay.
That is what I was, that's what I meant.
Well, and I'm not trying to be coy.
No, I didn't think so.
I don't know if the feedback on plain error has trickled down, but this is the same idea
Right.
of like, what's your real argument, and
So,
and
on that
don't get
point-
caught up in the rabbit hole.
circling back to that, I just wanted to address the officer's claimed suspicions here, that it was a high crime area. It was 10:30 in the morning in Coleraine on Pippin Road. The left turn without a signal was in a turn lane. That was more of a misunderstanding of the law than any sort of indication of anything else. Like the court, I don't see the nervousness, heavy breathing, or shaking hands. The bulge was no testimony.
Is that an issue of fact that you're asking us to determined differently than the trial court in your brief?
I think that's a complicated answer because I believe the court got it right in the first half of their statement, that they don't see it.
Right, but again, I think we all acknowledge that anything that takes place after the pat-down was complete, that it's really a totality of the circumstances, so anything that the officer was already apprised of can go into the calculus of whether there's a new basis for reasonable suspicion or or now we're at probable cause.
So that's, I guess, part of the reason
So it
I
seems to
addressed
me
it.
that would be something that would need to be challenged directly, that determination of fact was not supported by the record.
Well, in that case, I guess that ultimately is my position, is it's not supported by the record. There are certain things you could see, even if maybe you couldn't tell the extent of shaking. There's no heavy breathing. That's clearly not there. I honestly thought the officer was more nervous than Mr. Hill in this situation. And the one thing I wanted to point out is after the pat-down at 5:02 in the video, what the officer said is, "What all do you have in your pockets here?" Terry's about plain feel. So he was clearly a fishing expedition to ask that question, because he's essentially admitting, I didn't feel anything by plain feel. What's in your pockets? So for all of those reasons, I don't think.
So is the officer not allowed to ask questions once the pat-down is done?
I'm not
Because-
saying he can't ask questions. I'm saying that,
Especially, because what's interesting here is the bulge, there was a bulge. The bulge is the pat-down, is the basis for the pat-down, amongst other things. And then the pat-down doesn't reveal anything that's under Terry, and the officer testifies it's over, right? But there's still presumably a bulge that the officer's seeing.
well, he's also felt it at
Correct.
this point.
Correct.
And that did remind me of something. 3:15 into the video, because one of the things he relied on for the pat-down was his criminal history. 3:15 in the video, you can see the officer checking his terminal in his car, and you can see that those charges that he relied on, the domestic violence with the strangulation, you can see it says ignored on there. So factoring all of that together, I do not believe there was reasonable suspicion for a Terry pat-down. I don't think the Perry pat-down yielded anything, and I'd ask that the court reverse and grant the motion to suppress. Thank you.
Thank you. Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely decision. Enjoy the rest of your day.